Judgment in the matter of Rhuppiah versus Secretary of State for the Home Department.
Lord Wilson will give the reasons for the judgment.
When the Home Secretary decides to remove from the UK people who, under our immigration laws, are no longer entitled to remain here, they sometimes challenge their removal on the basis of their right, under Article 8 of the European Convention on Human Rights, to respect for their private or family life. These challenges, if successful, can arouse popular concern, which, at any rate on occasions, is understandable. Ms. Rhuppiah came to the UK from Tanzania in 1997 and has lived here ever since. She was allowed to come as a student, and because she successfully pursued various courses, she was given further leave to stay here as a student until 2009. In 2010, her residence here became unlawful, so the Home Secretary decided that she should be removed. She challenged the decision by reference to her right, under Article 8, to respect for her private life. In 2014, Parliament inserted into the Nationality, Immigration and Asylum Act 2002 a new provision, Section 117b(5), which said that little weight should be given to a private life established by a person when her or his immigration status was precarious. At all levels below that of this court, Ms. Rhuppiah's challenge to her removal has failed in the light of a conclusion that she established her private life in the UK when her immigration status was precarious. Shortly before the hearing of this appeal, the Home Secretary decided to allow Ms. Rhuppiah to stay in the UK on a different basis. For, having now lived here for 20 years, she had become eligible for leave to remain here, albeit initially only for 30 months, under one of the ordinary immigration rules. So the appeal has become academic. Nevertheless, we proceeded to hear it in order to decide what precarious means in the new subsection. Today we hold that if you're not a UK citizen, your immigration status is precarious if you have any grant of leave to reside in the UK which is other than indefinite leave. So, if in order to be allowed to reside here indefinitely, you need a further grant of leave, your status is precarious. We reject the submission made on behalf of Ms. Rhuppiah that even if you have only a reasonable hope of being allowed to settle here permanently, your status is not precarious. So her status was correctly held to have been precarious at all material times. Indeed, not that it matters anymore, it still is. The result of our decision is that very many of those who challenge their removal from the UK by reference to their right to respect for their private life are confronted by a law which indicates that little weight should be given to it. But in an exceptional case, their challenge can still prevail. For another provision of the 2002 Act requires courts and tribunals only to have regard to the provision in the subsection which sets out the consequences of a precarious status. So a court or tribunal might occasionally say that it has had regard to the subsection, but nevertheless, the facts are so exceptional that it has decided to attach substantial weight to the appellant's private life, and indeed, it might then proceed to uphold the challenge. We also take the opportunity to correct a subsidiary feature of the decisions below. It relates to another subsection, 117b(3), which provides that it's in the public interest that those who seek to remain here are financially independent. Ms. Rhuppiah is financially dependent on a friend with whom she lives and for whom she cares, and to a lesser extent on her father from abroad. It was held below that she was therefore not financially independent. The Home Secretary now agrees, and so do we, that that was wrong. Financial independence in the subsection means not being dependent on the state. We allow the appeal on that subsidiary point, but in the circumstances, it is only a formality.
Thank you very much. Court is now adjourned.